Welcome to this second training video for Municipal Land Use Commissioners prepared by the Southeastern Connecticut Council of Governments. In the first video, we talked about how to run public meetings. It is a good idea to start with that video first if you have not already viewed it. In this video, we'll be talking about a subset of public meetings called public hearings. To begin, public hearings are intended to give the public an opportunity to comment on consequential developments or changes. It is a time for individuals to voice their concerns and ask questions regarding specific proposals. The public can bring in experts and provide important testimony. The public may voice support or opposition to proposals. Public hearings give the residents of a community the opportunity to be heard by commissions before the commission votes on land use decisions. Just as importantly, hearings afford the applicant a fair and unbiased opportunity to present their proposal and request approval. Public hearings are required for certain types of land use applications. A Planning and Zoning Commission will require hearings for applications such as special permits, which are sometimes referred to as special exceptions, zoning regulation amendments, and zoning map changes. Zoning boards of appeals require hearings for variance applications and appeals of the zoning enforcement officer, and inland wetland commissions require hearings on significant activities or when a hearing is successfully petitioned for by 25 residents. Inland wetlands commissions also require hearing for regulation and map amendments. We will discuss these types of applications in greater detail in future commission-specific videos, but right now we will discuss how public hearings are conducted. Once an application that requires a public hearing is received, the Commission has a set time frame to open the public hearing. This time frame is determined by the date of receipt of the application. The date of receipt has a very specific legal definition, and it is not the date that the application is received in the office. The date of receipt is defined as the first regularly scheduled meeting following the submittal of the application, or 35 days after the submittal, whichever comes sooner. The public hearing must open within 65 days of the official date of receipt. This can be a bit confusing, so let's go over a few examples. In our first example, the Commission has regular meetings every third Tuesday of the month. If an application is submitted to the town on April 7th, which is the first Tuesday in April, then the date of receipt is April 21st, the Commission's next scheduled meeting. The Commission must open the hearing by June 26th, 65 days from the April 21st date of receipt. In our second example, the Commission meets only every other third Tuesday. We will once again say the application is submitted to the town on April 7th, but in this case the Commission will not meet until May 19th. Since that would mean the next meeting is more than 35 days from the date the application was submitted, the 35-day rule will apply. Therefore, the date of receipt is May 12th, 35 days from when the application was submitted. The hearing must open within 65 days of the date of official receipt, so the hearing must open by July 16th. Now, let's say an application is submitted to the Commission at a regularly scheduled meeting. Does the Commission have to open the hearing within 65 days of the meeting at which it was received? Actually, no. In that case, we'll say the application came in at the April 21st meeting. The date of receipt is the next scheduled Commission meeting, or 35 days from the date of submission, whichever is sooner. If the next scheduled meeting is May 19th, that will be the date of receipt, as it is less than 35 days from when the application was submitted. The public hearing must open within 65 days thereafter. Now, let's say a hearing has been scheduled. What needs to happen before the hearing can open? The state of Connecticut requires that notices of hearings must be posted in a newspaper having substantial circulation in the municipality in which the hearing is occurring. An example is shown here. You'll see that the hearing notice includes the date, time, and location of the hearing, and also states what the subject of the application is. Notices must be published in the newspaper twice before the hearing, the first between 15 and 10 days before the hearing, and the second between 10 and 2 days before the hearing. The notices must be placed in the newspaper at least 2 days apart. Your local regulations may also include additional pre-hearing notice requirements, such as posting a sign on the subject property or mailing notices to neighboring property owners. These local requirements must also be met before a hearing can commence. Once all of the notice requirements have been fulfilled, the hearing can open. To begin the hearing, a commissioner must make a motion to open the public hearing. Another commissioner will second the motion, and then a vote will be taken. The chairman or secretary typically reads the public hearing notice into the record. This is the same notice that is posted in the newspaper. Once the hearing is open, the applicant or their representative will be asked by the chair to present the application. The applicant may present their own application, or they may have an attorney, engineer, or planner speak for them. Their presentation may include multiple presenters, perhaps including an architect, an attorney, and a traffic engineer. These are often referred to as experts. This is the opportunity for the applicant to present their application and state why they believe that, based on your regulations, their application should be approved. Therefore, it is very important to pay close attention. Many commissioners choose to take notes to remind them of points that they want to revisit. At the conclusion of the presentation, the chair will ask if any commissioners have questions of the applicant. If you do, you should first be recognized by the chair to ask your questions. Unseated alternates are permitted and encouraged to ask questions at this stage in the hearing. Once the commissioners have asked their questions, the public will be invited to comment on the application or pose questions. Questions from the public should be directed to the chair so that there is no crosstalk between the public and the applicant. The commission must allow any member of the public to comment who wishes to speak. If there is a crowded room, the chair can advise a time limit on initial comments to give everyone a chance to speak. Those with additional comments should be allowed to speak again at the end. During this portion, the public may bring in experts, which essentially means people who have noted expertise in the subject area. The applicant may also bring in more experts during this time if they had not already presented. The commission can also call on their own experts if they would like something verified. For example, if the applicant supplies a traffic study that the commission believes is erroneous, they could choose to contract with a traffic engineer to provide a second opinion. The commission will likely also have questions for their staff, including the planner, zoning enforcement officer, or town engineer. At the end of the public comment portion, the chair will ask for clarification from the applicant on any points raised by the public. The commission will then have a choice: to close the hearing or continue the hearing to a future date if the commission feels more information is required. Some examples of these types of motions are shown on the screen. The commission needs to vote on a motion to close or continue the hearing. If the hearing is continued, the public and applicant would once again be allowed to comment at the future date. A hearing must be closed within 35 days of its initial opening. Depending on the way the agenda is arranged, deliberations will occur immediately following the close of the hearing or later on in the meeting. Deliberations could also occur at a future meeting. Deliberation should begin with a motion and a second to the motion regarding the approval of the application, so discussion can ensue on the merits of approving or denying the application. During deliberations, alternates who are not seated should not comment any further on the application. Again, after the public hearing portion of a meeting is closed, the commission should not ask any further questions of the applicant, nor should the applicant or any member of the public be permitted to comment. If comments were allowed, the public or the applicant would not be able to adequately respond, and therefore any decision made allowing such comment could be appealed to court. During deliberations, the motion may be amended if the commissioner who originally made the motion is amenable to the change. Once the motion is finalized and any conditions are added, and there is no further discussion, the chair will call for a vote. The commission has 65 days from the date of the close of the hearing to render a decision. If you are an inland wetlands commissioner, this time frame is decreased to 35 days. All of the deadlines mentioned previously regarding the time allowed to open, close, and render a decision on a public hearing can be extended by up to 65 days in total if the applicant requests such an extension in writing. The 65-day extension period can be divided between the three deadlines. In other words, 20 days could be granted to extend the time to open the hearing for a total of 85 days as opposed to 65. 15 days could be granted to extend the public hearing to 50 as opposed to 35, and 30 days could be granted to extend the decision time to 95 days as opposed to 65. Note that when you add those extensions together, they do not exceed 65 days in total. Please note that extensions may not be granted for newspaper publication deadlines. This video contained a lot of information that may seem overwhelming. Note that in most cases, your staff planner will likely be taking care of all of the deadlines mentioned throughout this video. While the specifics are important to know for background information, it likely will not be your responsibility to keep track of these timeframes. With that said, the most important thing that can be said about public hearings is that they must provide due process for both the applicant and the public. Public hearings are the backbone of public participation in land use decision-making, and as such, commissions must work hard to ensure that all who would like to participate get a chance to do so. Information may arise from public comment that may have been unknown to the Commission and potentially even to the applicant. That type of information could change the course of a decision. As a reminder from the previous video, it is important to be professional during a public meeting, but especially during a public hearing. Therefore, it is once again worth mentioning that joking should be avoided. And finally, the Commission should always have the goal of rendering unbiased decisions based solely on the merits of the application and how the application complies with local regulations. Thank you for watching this training video. We hope it was helpful. The next training video will include information on how commissioners should behave inside and outside of public meetings to avoid issues like conflicts of interest and predisposition. We welcome any suggestions you have for future topics. Have a good day.